My name is John Lande. I'm on the faculty at the University of Missouri Law School. I've been here since 2000. I've been focusing on dispute resolution for my entire academic career, and I've been teaching a negotiation class for about 2 years now, and I'm going to talk about how I came to teach that. I wrote a book called Lawyering with Planned Early Negotiation that captured my understanding about how lawyers work, particularly in litigation. And this grew out of research that I'd done on a process called collaborative law. About 10 years ago, I started studying collaborative law, which is a relatively narrow procedure that's used almost exclusively in divorce cases. The essence of it is that the lawyers and the clients agree at the outset that they're going to start with negotiation, and indeed in collaborative law, they aren't going to litigate at all. If the parties want to litigate, then they have to dismiss the collaborative lawyers and hire new litigation counsel. And this is a contrast to the normal model of negotiation and litigation, which is lawyers gear up to litigate and to prepare for trial, and then after they have completed discovery and are ready to go to trial, that's when they start to negotiate. That's got lots of problems in terms of inefficiency, and also it aggravates the relationship between the parties. So I was intrigued about this collaborative law process, which starts with the negotiation. And I was also intrigued because I knew that there are some lawyers who, even though they aren't collaborative lawyers and don't do a formal collaborative law process, essentially start by trying to negotiate relatively early. So I was very interested in how lawyers would do that, and always being prepared for the clients to go to trial if needed, but to start with negotiation at the outset and to integrate sort of a negotiation strategy into the way they handle the cases all the way through. So it kind of grew out of my study of collaborative law. The biggest difference is that law students get a much more realistic understanding and experience of what it's like to handle a case and to see how negotiation fits in. The traditional way that negotiation courses are taught in law school is by having students do a series of one-stage simulations. Basically, you're given fact patterns, or instructors give the students fact patterns, and they are going to, what I call, parachute in at the end of the case, and just before the case is about to end, they've collected all the information presumably, and then they are going to enter into this negotiation of the final issues. In real life, lawyers have to develop the case from the outset. They have to meet their clients, they have to get some information, they have to develop a theory of the case, they develop some relationship with their counterpart lawyers, and they do some planning. And so it's a much more of an organic process where students have that feeling, and certainly some of the feedback I've gotten from students in the class is they have more of a sense of what it's like to be a lawyer, whereas when they do the one-stage simulations, it feels more like a game, that they're just sort of given a role and they play a little role, whereas these multi-stage simulations go on for several weeks and they're really much more into it. Part of what this also does is it provides me and the students an opportunity to focus on specific stages in the process and see how each of the stages relates to each other. So for example, they do an initial client interview and they learn about what the facts are and what the client's interests are and what the perspectives of the other side are. One of the things I'm very interested in is having them start to think about what information they're going to be needing, and then also developing a relationship with their counterpart lawyer, which is essential. And it's a much more, they get it. Students, when they do these multi-stage simulations, they have a feel for what it's like to be a lawyer much more than doing a lot of one-stage simulations. Now, in my course, at the beginning of the course, I have them do a number of one-stage simulations and also what I call fishbowl or improv simulations, where they do very small scenes. And the way I've structured the course is at the end of the course, the second half of the course, they do 2 multi-stage simulations. So it's the culmination of the course, and they do one dispute resolution simulation of a probate dispute, and then one negotiation of a transaction of negotiating a partnership agreement. And by doing two of them, each student gets a chance to play a lawyer and a client. So they get a really much richer experience of what it's like to be a lawyer, and it builds on the first part of the course where they do these one-stage simulations where I can focus on discrete issues like building trust or dealing with emotions or all the sorts of things that people tend to talk about in negotiation courses. The main thing that I really wanted them to get was to have a sense of how the negotiation of the final transaction or the final resolution of a dispute would grow out of the earlier stages, and how the relationships between the lawyers and the clients and between the counterpart lawyers was really important. So really focusing on what it was that I really wanted them to do. Related to that, there are a couple of things that I think are really important. One is developing the relationship between the lawyer and the client, and so I think a lot of times people assume that lawyers will understand what the clients want and will just simply advocate for that, and practicing lawyers know and academics know that in fact the relationship between the lawyer and the client is a challenging one and evolves over the course of a case. And so starting off with having that relationship between the lawyer and the client and having students really feel that, not just have them read it, but develop a relationship between students who are playing these roles, is a really important one, and eliciting information and really understanding what the client's goals and interests are is really important. A second thing that I think is really, really, really important that's hardly nowhere in law school education, as far as I know, is developing the relationship between counterpart lawyers. The model of the relationship between counterpart lawyers or opposing counsel, is typically called in legal education, is as courtroom adversaries. And certainly lawyers are courtroom adversaries. That's one of the things that they do, but they also cooperate with each other in certainly pretrial litigation and in developing a transaction. They need to do all sorts of things where they coordinate with each other. And the relationship that lawyers have with each other makes a huge difference in how the case is going to unfold. And certainly in this last bit of research that I've been doing, I've been getting a tremendous amount of feedback about that if you have a good relationship with your counterpart lawyer, then the case is going to go a lot better in general. And if you have a bad relationship, then it can be your own private hell. So having students think about developing consciously the relationship with their counterpart lawyer is a really important thing. One thing that I've had students do that has worked remarkably well is to have one of the stages in the multi-stage simulation, have them go to lunch. Sometimes it's been a simulated lunch where it's in a classroom. Other times they've actually gone to lunch. But in any case, they spend a half an hour to an hour just getting to know each other. I tell them at the end, if they want, they can talk about the case, but the idea is just to develop a relationship and to find out about who they are as people. And I've gotten lots of feedback from students about what a huge difference that made later on in the case, where they ran into problems, and it was because they had a relationship and they had developed some degree of trust that they could get through some problems. So having students appreciate the relationship between the counterpart lawyers is a really important one. The other thing that I did that I think is really worthwhile in dispute resolution courses was I have used a system of ungraded quizzes, pop quizzes, and I was surprised that in the focus group students really responded well to that. And the way I do this is I will ask them typically just one question based on the reading for the day, and it may be a question like, what was one of the most important points in so-and-so's reading, or how would you apply it in real life? Not really asking anything too specific or nitpicky, but just trying to get them to think about one of the major points in the readings. That did a couple things. One, part of my motivation was to get them to be sure to do the reading. In a lot of dispute resolution courses, a lot of students can get by and fake it without doing the reading, and there's a lot of motivation to not do that in law school culture. It was also useful for me to get some feedback from them in terms of what they were getting from the readings, what they thought was most important. And then what I would do is, after they would take a minute or two to write out an answer, I would collect it, and then that would be the basis of 5 or 10 minutes of discussion at the beginning of a class. So that really worked well. So those were some of the things that I thought were especially valuable.